Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dahil hindi Anglican po, verbal blood. That's literally not true.
Alrighty. Welcome to the Court of Public Opinion. I am the Recovery Addict. Welcome back, I should say. It's late in the evening. I need to turn that down just a little bit. There we go. That's better. Let's get some chat going there, shall we? There it is. And why is that separate? Okay, we'll shrink this down, make this full size, and call it good. There we go. All right. Just minutes ago, we had some breaking news with the plaintiff filing their response to the documents. Oh my goodness! Justice Obsessed, you were first in chat this evening. You win the internet. Congratulations, my condolences. It's all wrapped into one big package. It's like the early Christmas gift you didn't want to receive, but the internet is all yours to take care of. So please do that for the rest of us, and we'll count that as a personal favor. Thank you so much. I have a little bit of water, which I brought in this mug. For those of you who don't recognize this is a Starbucks. I think it's a insulated thermos, like the Stanley thermos by Starbucks. I brought it without the lid. And you can see from the little reflection it's full. And I'm wearing about half of it now because in my exuberance, I poured it all on my lap. So no, those are asking, no, I did not have an accident. I just poured water all over my lap to kick things off because that's how we roll. But here we are. Let's see, let's get this out here. Plaintiff's response. Make this nice and big so I can see it. Actually, I can go full screen on this one because that's how it works. And here we go. We're going to kick this off right away with the response because it is fantastic. Oh, first of all, I forgot. Let's see this. Boom. There you go. Justice Obsessed, thank you. You earned the right to have your remark pinned there. We have pinned you just a little bit. Thank you so much. True Crime Junkie, the OG, member for 7 months. Yay, love it here. Thank you so much. We're going to kick this off right away. No big drawn-out intro at all. Elizabeth, welcome to the gallery as well. Thank you so much. I'm going to try to keep an eye out for chat just a little bit, but let me start with this. This is the plaintiff. So this is Mr. Anderson, Mr. Whitney, responding to what the defense posted as what we call the juror number 1 motion. And so here we go. Plaintiff's response to defendant Johns Hopkins All Children's Hospital motion for new trial based on juror misconduct, motion for juror interview, motion to open discovery into evidence of juror in misconduct, and emergency motion to preserve evidence. That's what they called it last time, and they're calling it the same thing this time. But this is a response to this. Plaintiffs Jack Kowalski, individually and on behalf of his child Maya Kowalski, a minor. Kowalski, I keep slurring that a little bit. As a personal representative of the state of Utah, by and through undersigned counsel, hereby files its opposition to defendant Johns Hopkins All Children's Hospital motion for new trial, motion for juror interview, motion to open discovery into evidence of juror misconduct, and emergency motion to preserve evidence, and says, the motion, they start with snark, the motion, which really should be entitled juror misconduct by proxy, should be denied in its entirety for the following reasons. Wow. It was, oh my goodness, it was hilarious. A, defendant failed to preserve its juror number 1 challenge. This failure to preserve a challenge is important. Everything has to be done timely, and if in court, if you don't make the objection at the right time, you lose the right to make a related objection later on. You have to sort of lay the groundwork to get to a certain point. They're saying besides asserting an incorrect standard and basing its allegations on asserted posts of people other than juror number one, defendant failed to preserve the arguments it now makes after the verdict. The pre-verdict information on which the defendant relies was available and it appears known to the defendant before the verdict. Yet the defendant waited to see how the verdict came in before bringing these assertions to the court. Had it acted timely, if its claims had any merit, they could have been addressed before this 9-week trial went to the jury. Over 20 years ago, the Florida Supreme Court stated the court system is already overburdened and does not have the luxury of allowing jury verdicts to unravel or be subject to attack because of information which could have been reasonably obtained before the trial begins. The same rationale applies to information that could have been discovered during the trial and when an alternate juror could move up to deliberate. In 2002, the court said, in a perfect world, access to the information would be immediately available and all courtrooms are actually provided as jury pool information. Because of advances in technology, that day has arrived, and it may be appropriate for the courts to revisit whether parties have a duty to investigate juror backgrounds before the verdict. But the court need not reach that issue to see the defendant fail to preserve its argument here. The defense bases its motion largely on internet posts during the trial, as noted below. To the extent it refers to alleged comments after the trial, jurors are free to discuss their service when the trial has concluded. Those materials were available to the defense in real time. Defendant claims it strains credulity to believe juror number one and his wife were not communicating with each other during the trial. Defendant is wrong. First, the court told the jurors repeatedly they were not to discuss the case with anyone, even family members. As noted below, to engage in the unsupported assumption defendant posits would mean there could never be a married juror. So no, it does not strain credulity to believe the jurors follow instructions. Second, as discussed below, evidence shows defense counsel was actively engaging with members of the public through the internet during the trial, and therefore, all the pre-verdict posts defendant complains about in the motion should be considered known to the defense team before the verdict. Defendant has not denied it knew about these posts in the motion, and if it does, the members of the defense team should be placed under oath and questioned, but that should not be necessary. Where a lawyer knows of an incident potentially compromising the jury before a verdict is returned, but fails to object or alert the court until after the verdict is announced, the incident may not be raised as a ground for a new trial, and they cite case law, Rooney versus Hannon. The second district holds the same. When it was discovered during deliberations that the bailiff had left the judge's copy of instructions with changes made during the change conference in the jury room, the defendant's objection was untimely because it was not made until after the jury had delivered an adverse verdict. I'm going too fast, says my wife. Slow down. So what does it mean? Basically, they're saying you missed it. You had your chance. You had your chance, so you didn't do it. First of all, and they're doing it with spice on every single thing. So you knew about these internet posts in real time. You didn't do anything. You were on the internet yourself in real time and you didn't do anything about it. You can't bring it to the court after you lost on the verdict side and say, now we want, justice. Joshua gifted 5 memberships. Thank you so much, Joshua. Slow down and take a drink. I'm so excited. I will slow down. Okay. I'll try not to wear it this time. That's cold and it's water. It's very good. All right. Deep breath. The second district holds the same. When it was discovered during deliberations that a bailiff, we read that part. It's untimely because it was not made till after the jury just delivered an adverse verdict. In sum, defendant's erroneous argument is not preserved. That means they don't have grounds to stand on at this point because they didn't do the right thing when they knew about it. Okay. Part B, defendant has not presented legally sufficient prima facie evidence of misconduct by juror number 1. The correct legal standard for a juror interview. They list some case law. The Supreme Court set forth that showing must be made before a trial court can permit a juror interview. In doing so, the court emphasized the strong public policy against allowing litigants to either harass jurors or to upset a verdict by attempting to ascertain some improper motive underlying, and held that an inquiry is never permissible unless the moving party has made sworn factual allegations that, if true, would require a trial court to order a new trial. The court stated, the case law on this topic allows the fact-finding process inquiry only into objective acts committed by or in the presence of the jury or a juror that might have compromised the integrity. We don't have any of that. Because defendant's motion contains no objective acts that were committed by or in the presence of juror number 1, defendant has failed to carry its burden. The end. No, wait, there's another 120 pages. The motion supports the request to interview juror number 1 solely by inferring that he has violated the court's instructions based on the conduct of his wife and others. In effect, the motion asks the court to impute the actions of the statements of juror number 1's wife and others to him, misconduct by proxy. I give case law. Merchant v. Estate involved a similar attempt to use the assumptions and inferences to conclude that jurors had violated the court's instructions not to discuss the case. There, the trial court became aware during jury deliberations that a brother and sister had served together on the jury until the brother, the alternate, was discharged. The trial court declared a mistrial. The court stated, I can make the presumption they are brother and sister, and I found out they have driven back and forth together. They must be talking about this. The appellate court disagreed. This is with family members serving together on the jury. The appellate court disagreed. And they cited the ruling there. We're not going to read the ruling exactly, but basically they overturned that decision. A motion seeking to interview jurors that is based on mere conclusatory statements based on speculation and surmise that if interrogated, the jurors might have something to say that would be material to whether or not the court should award a new trial is insufficient. KBF defense should have asked for sequestration, but they didn't, so they've waived all their whining about juror number 1. Get wrecked, Hunter and Shapiro. That's a strong way to put it, but basically that's what we're hearing from the plaintiff, saying you had your chance. Let's see. Case law, Albertson versus Johnson. A motion for interview of a juror will fail where there was no suggestion in the record of any misconduct or irregularity on the part of any juror. Here, juror number 1's wife did not serve on the jury with her husband, and there is no reason to assume juror number 1 disobeyed the court's instructions not to discuss the case with anyone merely because he has a wife. Defendant acknowledges through the motion that it has no evidence juror number 1 violated his oath. Quote, this motion sets forth a reasonable basis for belief that juror number 1, the foreperson, engaged in presumptively prejudicial misconduct, emphasis added. And juror number 1's spousal social media posts highlighted her heavy personal bias in favor of the plaintiffs, a bias apparently shared by her husband, emphasis added. And it's strange credulity to believe that juror number 1 and his wife were not discussing the case in violation of the court's instructions, emphasis added. Those are not objective acts committed by or in the presence of juror number 1 as required by Mailer. In the conclusion of the motion, the defendant again acknowledges it has no evidence of actual misconduct by juror number 1. Where they, and this is a quote, page 38. It strains credulity to believe that juror number 1 and his wife were not sharing information regarding the case, particularly given the nature of their social media participation. Defendant does not have to prove actual misconduct to be entitled to a juror interview under Florida law. Rather, defendant only has to establish a reasonable belief that misconduct occurred to be entitled to interview of juror regarding presumed misconduct. The circumstances here are very different from those in the authorities cited in the defendant's motion. So basically, the case law they used was different than the situation we're in. In Amazon v. State, the trial judge learned of multiple undisputed instances, objective acts, where sequestered jurors had violated the sequestration order by spending time together in a bar, having dinner with a third party, as well as 2 jurors watching a news account of the trial on television, albeit with the sound turned off, following which one juror remarked to the other that the state witness's testimony had been impressive. Likewise, in Norma v. Gloria Farms, the plaintiff learned the undisputed fact the jury foreman's brother was an employee of the defendant's insurance carrier. Wow. Defendant had cited no cases, and plaintiff is aware of none, where a juror interview has been based on inferred conduct of a juror or conduct of a third party's imputed to a juror. Misconduct by proxy.
So they just learned the last of the 2 examples that they had given, the 2 case laws.
Yeah, so they here we've got the plaintiff just ripping apart the case law that the defense is using to cite their case. Funny, when they wanted juror number 1 dismissed, they didn't want the judge to question him. They didn't. They did not. They said, we don't want you to question him, just excuse him. Mara C., not that they use the wrong case law. They're finding case law that's relevant to this type of issue, but the circumstances that bring about the parts they're quoting are very different from what they're experiencing. So they're cherry picking from case law things that make it sound like they have a strong case. Here the plaintiff is saying, now read the background, and that's a completely different situation that justifies that. Debbie, this is a response to the plaintiff's motion, a response to that juror number 1 motion, and it's filed by either Mr. Anderson or Mr. Whitney. We were waiting for this one. We knew it was coming in today. Okay, part 2, the correct legal standard for the new trial based on alleged juror misconduct. The motion also states that potentially harmful juror misconduct is presumptively prejudicial. This is an incomplete and therefore incorrect statement of the standard to determine whether alleged juror misconduct, if established, requires a new trial. In Amazon, the trial that was referenced above, the defendant argued that the undisputed evidence that the jurors had violated the sequestration order placed the burden on the state to refute a presumption of prejudice raised whenever juror misconduct is shown. The Florida Supreme Court disagreed, stating that the position urged by the defendant is not the rule in Florida, as one of the cases cited by Amazon explains.
What just happened? So what did they just say?
They said, if the misconduct is such that it would probably influence the jury and the evidence in the case is conflicting, the onus is not on the accused to show that he was prejudiced, for the law presumes he was. But it should be clearly understood that not all misconduct will violate the verdict, even though such conduct may be improper. It is necessary either to show that prejudice resulted or that the misconduct was of such character as to raise a presumption of prejudice. In other words, potentially harmful misconduct is presumptively prejudicial, but the defendant has the initial burden of establishing a prima facie case that the conduct is potentially prejudicial. Let's skip down here. The new trial ultimately ordered in Norman was based on the objective facts of the juror's familial relationship with an employee of the defendant's insurance carrier. Defendant has provided no authority, and plaintiff knows of none. Hey, Kurt, welcome. I should have gone live on StreamYard.
Okay, so they just said this last case.
They can't hear you. I can hear you, but they can't hear you.
I'm just trying to figure this
Mrs. R.A. is reading this along with me. She's eating this up. Defendant has provided no authority, and plaintiff knows of none, where the prima facie case of prejudicial conduct required to order a new trial is established purely by inference or imputation of the conduct of others to the juror, i.e. misconduct by proxy. It says there's no case law. There's no authority to say you can get what you want using just the fact that the juror's wife posted something. The record regarding juror number 1's conduct or lack thereof. Like all jurors at the beginning of the trial, juror number 1 took an oath to follow the instructions of the court. I'm not reading the Latin. Inter alia. At the beginning of the trial and at every break thereafter, the court instructed the jury to refrain from speaking to everyone about the case, from doing independent research, and from forming opinions about the case prior to their deliberations. On each occasion, when the proceedings resumed, the court asked whether the jurors had followed his instructions, and juror number 1 always answered that he had. Florida recognized a presumption that jurors will follow their oath. We presume that jurors follow the trial court's instructions. As stated above, defendant acknowledges through the motion that it has no evidence that juror 1 in fact violated his oath. Like the motion, the supporting affidavit of defense counsel Shapiro only contains his suppositions and theorizations about whether juror number 1 in fact violated his oath, and relies largely on the fact that juror number 1 and his wife are married, from which he infers that they must have discussed the case. Shapiro mentions this in his motion. Excuse me, sorry. Laura Bronson, thank you very much for the super sticker. Love it. Defendant cites no authority supporting the argument that improper juror communications can be inferred from the fact of a juror being married. Indeed, if that were a legally sufficient basis to challenge a verdict, every verdict in every case rendered by a married juror would be subject to challenge. The extent to which the motion reaches for any purported factual basis is best demonstrated by the reference to juror number 1's post-verdict online statement. "Oh boy, I'm in trouble once again." Emphasis in the original. From the two words "once again," the defendant surmises the comment indicates that he knew from conversation with his spouse prior to being released from the courthouse that the defendant had moved to dismiss him as a juror. Patently, this is pure conjecture, and once the trial concluded, there would be nothing wrong with all the jurors learning what went on during the trial that they had not seen. Otherwise, all the matters that defendant contends show misconduct by juror number 1 are matters anyone watching the trial could know. Defendant has focused its fire against juror number 1 on 3 primary targets: juror number 1 himself, juror number 1's wife, and a member of the public gallery and social media commentator known as Jules. Although defendant's motion is scattershot and the connections between each of these individuals' conduct and any so-called juror misconduct are never drawn by defendant, plaintiff will address each in turn to demonstrate the absence of any basis to establish juror misconduct. Juror number 1's alleged direct actions. Question regarding creature comforts. The most pointed allegation made against juror number 1 in the defendant's lengthy motion concerns alleged outside research performed by juror number 1. Specifically, defendant's counsel claims, without basis, that juror number 1 learned of the concept of creature comforts from Dr. Kirkpatrick's RSD Foundation website. But like each of defendant's other unsupported claims, defendant has no facts, but only conjecture. First, it must be emphasized that defendant does not stop at one claimed instance of internet research, but broadly claims, without basis, that juror number 1 inappropriately conducted internet research on one or more issues in this case. Despite that bold claim, defendant never tells the court or plaintiff what other issues those might be. There is only one issue arising from alleged internet research, specified in defendant's motion. The motion states, the phrase creature comfort was not used by any witness at trial, but is used on Dr. Kirkpatrick's RSD Foundation website related to ketamine treatment. This statement is demonstrably and categorically false. In Ms. Rachel DeYoung's testimony on September 28th, she testified regarding so-called creature comforts. And this is straight out of the trial record. Mr. Anderson says, and by the time she left you and give the jury just an estimate of when you were hoping she could get out of the wheelchair, Ms. Young, before the hospital or after? Mr. Anderson, after. Ms. DeYoung, the goal was before school, and so, let's see, here we go. So I think in August the school started. I'm not sure. Mr. Anderson says September at that time. Ms. DeYoung, September. Mr. Anderson, but she was not able to do that. Ms. DeYoung, no, we were really close, and then the pain was too unbearable, and I said, maybe Christmas, and she's like, no, I don't like that answer. So she went home, and she said that it's up, that's it. And she put on her backpack, got out her crutches, and made herself walk in the hall. I believe maybe she didn't want to put herself in such a high pain position, maybe in public in the clinic at Agility. Maybe she didn't know how it was going to make her body, her emotions respond, and that's why she didn't want to do it in therapy. She wasn't sure. But at home, she has her creature comforts. There's the word, her phrase. Her dad, her brother, maybe her favorite show. She can call a friend if it's not, she's having a really bad time with it, and after her experience to try and walk. But she did very well. Juror number 1's use of the phrase creature comfort came 11 days later on October 9th, which was the trial day 11. Juror number 1 asked, Maya, during your stay at Johns Hopkins All Children's Hospital, you were at some time not able to view TV. Only a ticking wall clock was available to you. While you were at Johns Hopkins All Children's Hospital, did staff inquire if they could assist you in any way, such as adjust the TV channel, the volume, bring an item closer, further, adjust your bed, not counting the 48-hour EKG? When it comes to creature comforts, were you made to feel comfortable, or were you made or just felt you were in a hostile place? Defendant's counsel did not object to this question or raise the allegation of outside internet research in its pre-verdict motion to disqualify juror number 1, although the defendant had nearly a month to do so. Defendant's attempt to disparage juror number 1's integrity is not only untimely, but overlooks the testimony of Ms. DeYoung in favor of an unsupported theory that juror number 1 combed Dr. Kirkpatrick's RSD Foundation website to uncover the concept of creature comfort. Okay. Finally, creature comforts is a common expression and was the name of a successful film, a television series, and an advertising campaign. See Merriam-Webster's dictionary. Juror number 1's post-verdict comments. Juror number 1's post-verdict comments are immaterial to any consideration of alleged misconduct. The court expressly told the jury they were free to talk or not talk, to reveal their thoughts on the trial and their experience on the jury or not, based solely on each juror's discretion. And here's the actual instruction the judge read, the instruction to not talk about the case. The case is over. You're free to do whatever you want. That's the full instruction. Juror number 1 abided by his jury as a juror during trial, and the court already assessed juror number 1's alleged bias and prejudice against the defendant. On November 6th, this is juror number 1's potential disqualification addressed on November 6th, the court heard defendant's motion to disqualify juror number 1. The court denied defendant's motion after a lengthy discussion on whether juror number 1 had displayed any sense of bias or prejudgment. The court equivocally stated, unequivocally, I have not seen anything in my mind that would remotely come to me to get the conclusion that he is prejudiced prejudged anything in this case. On the contrary, I am warmed by the fact that he has, in his mind, gone through, or what I believe to be his mind, based on the questions that he's asked, my observation. I mean, the guy sits, 5 yards from me? I've been watching him for more than 2 months. I mean, he's the closest juror to my physical vantage point and location, and I've been watching the guy, and I have not only do I not have a doubt, I don't have a reasonable doubt, but I have no doubt this guy has not come up with any final or fixed opinion. The court's observations are undergirded by one of juror number one's questions. Towards the tail end of the defense case in chief, juror number one asked nurse Sylvia Wagner the following. Your positive vibes are like a breath of fresh air. Did Maya ever mention any staff that she was not too keen on? The court reiterated later that it had no concerns about bias of juror number one. So juror number one's juror questionnaire. The defendant alleges that juror number one's juror questionnaire was incomplete, inaccurate, and otherwise deceitful. The single paragraph in the motion making this assertion, however, fails to proffer any verifiable facts. It's got issue of Deborah Salisbury. The motion asserts juror number one never disclosed on his juror questionnaire during the voir dire that Deborah Salisbury Esquire was involved in juror number one's wife's domestic relations proceeding in 2007. Defendant, however, admits in footnote that defense counsel does not know whether attorney Salisbury represented juror number one's wife in that matter, and defendant does not claim the referenced domestic relations proceeding involved juror number one. It did not. Nevertheless, defendant claims that Ms. Salisbury was definitively involved in juror number one's wife's domestic relations proceeding. Going further, this defendant alleges misconduct because juror number one never disclosed this fact. What fact? The juror questionnaire asked whether juror number one knew Deborah Salisbury Esquire, not whether his wife knew her. The court should take judicial notice of a fact that apparently escapes defense counsel. Spouses can and do have different professional and social contacts and have separate lives before they marry. The paragraph in the motion addressing this Deborah Salisbury fact also does not establish that juror number one's wife even knows Ms. Salisbury. Defendant draws no connection between what appears on the Sarasota County Court docket and any relationship between Ms. Salisbury and juror number one's wife, which must first be established. Defendant offers nothing to show that juror number one has ever heard of Ms. Salisbury. Importantly, Ms. Salisbury never testified in this case. Even if defendant's counsel had been able to draw concrete connections between Ms. Salisbury and juror number one's wife, and then from there demonstrated that juror number one also knew Ms. Salisbury based on Ms. Salisbury's alleged encounter with his wife some 16 years ago, the court and the parties would be left with a quandary. What possible difference would any of this make in a case where Ms. Salisbury did not testify and her name was excised from any written communications to avoid injecting Chapter 39 and dependency court issues into the trial? As the court is well aware, the juror questionnaires provided in voir dire were thorough, specific, and drafted with the intent to weed out any potential conflict. Juror number one's juror questionnaire indicates his honesty. He clearly indicated his law enforcement background and checked yes to criminal history for either himself or an immediate family member. Juror number one's wife alleged professional encounter with Ms. Salisbury is a red herring and wholly irrelevant to juror number one's ability to assess this case as a juror. Part 2, the Take Care of Maya documentary. I need some water. P. Wilfredo says, recovery addict, if Maya lost this trial and we found juror number one's wife was a fan for the hospital, would we still think it wouldn't matter? Hypothetically, what do you think? Be well for real. I think I have a fairly good track record of agreeing that the jury was in the best place to make a decision. That the outcome they came up with was the right one. If you look back on all the cases we followed, I haven't always been right with my guess as to what would happen, but I think that track record can speak for itself.
I would be bugged, but I would not think it was right today.
Sorry, I said she'd be bugged, but I don't think it was right.
I don't think it's enough to kick it out.
I don't think it's enough to kick it out. Okay, Take Care of Maya documentary. Defendant makes an unsupported logical leap in alleging that despite juror number one denying in his juror questionnaire that he had seen the Take Care of Maya documentary on Netflix and further denying having any conversations or overhearing any conversations concerning Take Care of Maya, that this seems unlikely. That is it. This seems unlikely. This is the extent of the defendant's proffer to dispute juror number one's answers to the Take Care of Maya questions on the juror questionnaire. There are no facts offered to create a credible dispute over juror number one's answers to those questions. The rest of the direct attack on juror number one is conjecture based on juror number one's wife's so-called heavy engagement investment and close monitoring of the case, the court docket, and her following social media of the movie producers for the documentary. These hyperbolic, inflammatory, and imprecise allegations against juror number one's wife are addressed further below. Defendant has not demonstrated that juror number one failed to disclose any facts on his juror questionnaire. So now to juror number wife's allegedly improper acts. Each and every time the following questions were asked by the court, countless times during the trial, juror number one and the rest of the jurors always answered in the affirmative. And this is the judge saying, I want to confirm while you're away, you did not discuss this case with amongst yourselves. You did no investigation. You received no information. Is that correct? Want to confirm while you were away, you did not discuss this case amongst yourselves. You did no investigation. You received no information. Is that correct? No one approached you about the case. Is that correct? You have not seen any media accounts about this case. Is that correct? Nonetheless, and without any evidence that juror number one's affirmative answers to these questions were untrue, defendant launches into unsupported theories about juror number one's wife's influence over juror number one's view of the evidence and the case during trial. I really wonder if juror number one has a case against the defense for like libel or slander or something like that. It's covered in court. I think lawyers they're protected because anything they do in the court, anything they do in the court, they're safe from. Thank you to my wonderful mods. If there's a problem, the mods will take care of it. Thank you very much. Okay, the plaintiff, do you want to talk?
Yeah, because
We have to get you. We have a mic for you. We just need an arm.
I just need to finish the sentence because there's just been so much listening to us by the defense and other people that I want to be clear. I would be bugged if I heard, if Maya lost and we found out that the spouse of one of the jurors was a really big proponent and did all these same things on the other side. I would be bugged, but I would not feel it was appropriate to either interview or to start over this whole case. I would just feel like, that should have been caught in voir dire. That's it. And that's the honest truth.
There you go. Well said. Well said. Yes, you're allowed to have different opinions. We just ask that everything's shared respectfully. Thank you, Megan. Feel free to share them. Let's be respectful about them, and we'd love to. If you can tag me in the message, just like do the @ symbol in my name, it will raise the possibility of I'll be able to see it as well. Catherine, welcome to the gallery as well. Love to see that green courthouse. Thank you so much. Okay, Micah says, RA, were jury members allowed to mention to family or otherwise what case they were selected for jury duty on? I don't know. But if they say, hey, I'm on jury duty, I have to go to the courthouse, the family's welcome to go to the courthouse. I mean, there's like one courthouse for each area, so it would be pretty easy to find out. All right. Juror number one's, plaintiff observes that defendant's position that one spouse's knowledge or action should be attributed to the other means the defendant's arguments are unpreserved as discussed above. The extensive online involvement of lead defense counsel's wife, discussed below. Oh, here we go. Lead defense counsel's wife, that's the Shapiro Facebook comments, leads to the conclusion that defense knew all this conduct before the jury retired. The failure to timely raise it was a waiver. Juror number one's wife's social media and internet involvement. Juror number one's wife's comment regarding juror number one's unexpected questions to Detective Graham. Defendant alleges that juror number one's wife's social media involvement indicates she had conversations with juror number one about this case. Defendant points specifically to juror number one's wife's comment on a YouTube stream. The juror LEO, law enforcement officer, will be asking questions. Essentially, the defendant contends that the only explanation for juror number one's wife's comment is impropriety. However, and this, as this court has pointed out, given juror number one's background as law enforcement officer, we could have expected that he was going to ask tough questions, sharp, cross-examination type questions. This court also pointed out that 9 weeks into this trial, I can tell you without any sort of certainty that juror number one has been testing the evidence in the case, every single witness. While I don't think he asked a question today, but I think he asked a question on almost every single question that wasn't by deposition. The court went further to say, and I go back to this person with a law enforcement background, and he's, in my mind, taking what is sharply conflicting evidence that both sides have skillfully and artfully put forward to this jury, and he's trying to make sense of it. After 1 week of trial testimony and hearing the jurors' questions to witnesses, it became evident that juror number one was going to ask a lot of questions. He consistently asked questions throughout both plaintiff and defendant's cases in chief. The juror, she's worried I'm going to type my password on the phone when we're live. I'm just trying to go into my my thermostat so I can turn it down about 10 degrees. Oh my goodness, I'm dying. There we go. Okay. The notion that juror number one's wife had improper communications with juror number one ahead of him asking questions to Detective Graham is meritless speculation. The court knew they would ask questions. Plaintiff expected it. Perhaps defendant's counsel was surprised by some of his questions, or more likely failed to appreciate that Detective Graham's abrasive nature and aggressive interrogation of Jack Kowalski would backfire. Juror number one's wife's comment regarding the jury deliberation note. Defendant's motion alleges that juror number one's wife's comment about the jury deliberation note was a result of inside information that she could only have obtained from her husband, juror number one. Emphasis is original. The comment reads, I think the note yesterday was frustrated jury that cannot reach money agreement and it will take days. Plaintiff's counsel had the same observation. It was evident that the jury was frustrated, as indicated by their second note that read, Y'all, we have not been able to locate any of the calculations about future amounts. Witness Kirby was on Zoom, and Whitney mentioned them today, and it was said that we'd have all of this at deliberation. Well, if we do not have it, we ain't found it in all these files. So without these witness figures, you'll be lucky if there's enough awarded to pay your gas to drive to court, or we'll be here till next Friday. That sounds verbatim. Do you guys remember that? That was so good. Shuri, bottom line, defense thought juror number one would go their way being ex-law enforcement, but he didn't. They allowed him through voir dire. Now they're skulking. Not only did they allow him, he was their very first witness that they accepted, that they said yes on. He was the first one on the list, and he went through the entire process, and they said, we'll keep him. They had every opportunity to use all their strikes. Okay, more importantly, juror number one's wife's sentiment that the jury was frustrated matched the overwhelming sentiment of the social media commentators and public followers of the trial. Hey guys, you might be here. Check out your names here and see where you are. Thousands of comments were posted to this effect. Below are some examples. Let's see. Michelle Darlene says jurors are angry. Pio says, I think the jury know the verdict by now, but have to put the numbers together. Megan Ann says, LOL, they mad ASF. Jamie Morris says, seems the jurors want this to be done and they can't agree because they're missing info. Kat D says, dude, jury wants to go home. How are the instructions going to keep them together and them another day? I think they'll be seriously annoyed. They clearly do have a verdict. So, congratulations. Oh, there's more. Bridget Silverstone, the jury is so annoyed. Jamie Morris says, seems the jurors want this to be done so they can agree, and they can't agree because they're missing info. More. We have more pages. They sound fed up. Jurors want only the amount to be put in the verdict form. I think they're annoyed they didn't have something they thought they would and were close to finishing if they'd have had it. Juror number one's wife needed no inside information to interpret this note. The jury told the court that they were frustrated over the numerical values that they could not find. Juror number one's wife's comment regarding the jury not liking Catherine Beatty. Defendant also alleges that juror number one's wife had inside information from her husband based on her YouTube comment stating they, the jury, did not like Kathy Beatty or any of the witnesses defendant presented at trial the day prior. Defendant ignores the most rational explanation for the comment. Juror number one's wife was present in the courtroom on the day that Miss Beatty testified and could see and assess the jury members' reactions to Miss Beatty's non-credible testimony, as well as the other witnesses' testimonies that day. Juror number one's wife's other social media presence. Defendant highlights multiple other social media comments made by juror number one's wife and focuses on her activity during live stream coverage of the trial on the Law and Lumber, Recovery Addict, and Lawyer You Know YouTube channels. They have a quote there, but they got it in a different order. Defendant states, on a nearly daily basis, juror number one's wife spent hours online engaged in commentary about the trial proceeding, both in real time and after the trial day had ended and the jury was sent home, including her husband, juror number one, with whom she resided. The online presence of juror number one's wife undermines defendant's main premise that she must have discussed the trial with her husband. Because she was active online, she had ample opportunity to learn that way about what was going on in the trial. Despite the large amount of time juror number one's wife apparently devoted to online commentary about the trial, defendant cannot produce a single post indicating a discussion with her husband regarding the case at any point during the trial. In each instance, and for each and every social media post by juror number one's wife, defense counsel ignores the common sense explanation. As an example, to explain juror number one's wife's comments reflecting concern over plaintiff's remaining time, cognizant of the 55-hour limit, defendant asks this rhetorical question, but why was juror number one's wife of the opinion that the plaintiffs were running out of time if she wasn't discussing this case with her husband? The rhetorical question is easily answered. Anyone with even a casual interest in the trial heard the court repeatedly caution plaintiff's counsel about their remaining time. The remaining time on the shot clock was announced at the end of each trial day. Defendant's suggestion that juror number one had a unique perspective on the shot clock, which he must have shared with his wife, is absurd. In fact, the jury probably had the worst perspective on the issue, since the shot clock announcements were made outside the jury's presence. Finally, juror number one's wife posted comment, "I think you're right," was in response to another post from an observer known as T-Bex. Shout out to T-Bex. Good job, T-Bex. T-Bex said, ma'am, being so combative makes it look like you care more about the narrative than just about giving honest testimony. T-Bex says, Anderson should just sit down. The jury will ask the good questions for him. And T-Bex said, this lady is acting like it's her job is at stake. It makes me wonder what management has said to her. So this is all about a witness. And her response, she responded to this comment. Juror number one's wife monitoring of the court's docket. Defendant next argues that juror number one's wife's posts reflect that she was even monitoring the court's docket and reviewing court filings, like we do. This ignores that many of the YouTube channels and personalities mentioned on the previous page of the defendant's motion and above regularly notified their audiences of recent filings by the parties and even read and analyzed the motions live on YouTube with thousands of trial watchers tuning in, like we're doing now. Juror number one's wife most likely obtained her knowledge of and comments on recent filings from these YouTube channels. But even if she were accessing the court's docket directly, she had every right to do so as a member of the public. At no point was the jury... Sorry, I lost a whole bunch of comments. Oh, my goodness. I'm sorry, it was frozen on my screen. If I missed your comments. Indy Cindy says, what a joke. Has any other juror come out to say they were coerced, pushed, or bullied to agree with juror number one? No. I think that answers the defense's issues. Let's see. I think I missed. Bottom line, defense thought that juror number one would go their way being ex-law enforcement, but he didn't. Okay, I agree. Sozi, 9 months. Congratulations. 9 months of support. The Yellow Courthouse, that is amazing. I'm so proud of you and happy for, for your sweet family. Still selfishly waiting on a channel with you and your wife, though. Thank you to everyone here. We have to do something together, Jen.
We are doing something.
She says we are doing something together. We're working on getting her a mic on here. Hit the like button also, says Christy Yellow. It really helps the channel. It already deserves it. Thank you. I don't just read super chats, by the way. If you have a question and you want to get it to me, if you do what P. Will for Real did right here, just tag me in the message. I can't read every message, but if you've got something pertinent to share, if you do this gives me the best chance of being able to read it. I think the family should have won 90% of the damage cases, but the fact that jury let them win 100% of the damages and they got more than what was asked for just makes me worried. I hear you, P. Will for Real. They got 105% of what was asked for. So that's interesting. Let's see.
Yes, but are you worried because you feel like it's wrong, or are you worried because you think that will give the defense?
Mrs. R.A. says, are you worried because you think it's wrong, or are you worried that you think that will give the defense a toehold? Okay. Let's see. Where do we stop? Juror number one's wife likely obtained her knowledge of and comments of recent filings from the YouTube channels, but even if she were accessing it, she's a member of the public. Juror number one's wife's presence in the courtroom. At no point was the jury instructed that their spouses were prohibited from observing the trial, either online or in person. All members of the public were welcome to attend, whether they had relationships with jurors, witnesses, lawyers, or parties. In fact, Mr. Shapiro's wife and children attended the trial on many days. Family members of Dr. Jenny Dolan and Dr. Tepa Sanchez also attended the trial. A juror's wife attending one day of the trial does not violate any law or rule or oath, and certainly does not indicate juror misconduct. Jules, a member of the viewing public's supposedly improper actions. Defendants focus on Jules, a member of the public who relayed her observations via social media and through various YouTube legal commentators throughout the trial, has no bearing on juror number one's conduct or plaintiff's counsel's actions in the courtroom. Period. The de facto agent allegation. The allegation that Jules was a de facto agent of plaintiff or plaintiff's counsel is preposterous. Jules played no role in the plaintiff's trial strategy or decision-making, and her opinions were hers and hers alone. See Declaration of Gregory Anderson, attached as Exhibit B. Jack Kowalski allegedly smiling and nodding at Jules after Judge Carroll denied defendant's disqualification motion. The video that defendant cites shows Mr. Kowalski raising his eyebrows and turning to the gallery. There is no footage or any indication that Mr. Kowalski is looking at Jules. In fact, Jules' head is down when the camera pans to her. One of the plaintiff's expert witnesses, Dr. Scott Richards, was seated next to Jules, and Mr. Kowalski was looking at him as the two discussed the trial throughout. 3. Internet social media activity. Despite the absence of any demonstrated connection of this pre-verdict social media activity to juror number 1, the motion complains that specifically the entire internet community was made aware of the heavy bias in plaintiff's favor on the part of the juror's wife, plainly compromising the integrity of the jury process. Leaving aside the question of how the defense was able to discern this information, what the entire internet community was aware of or thought, does not constitute misconduct by juror number 1. Moreover, defendant is hardly in a position to complain about internet and social media activity during trial by third-party observers, as demonstrated by the defendant's own robust internet activity during trial, as shown in the screenshots attached here too as Exhibit D. Defense counsel Shapiro and other members of the defense team were receiving substantial, ongoing feedback and support from the internet community throughout the trial. In a November 11th, 2023 message, Attorney Shapiro communicated that, "Hey, I want to thank you and everyone else who is sleuthing this so carefully and meticulously. I've gone through the Reddit thread on juror number 1 with almost 1,000 comments. Everyone on the defense team is monitoring this closely. If anyone in the community has comments to make, you can feel free to keep posting there, because we are going to read all of it and put it towards emotion." It says emotion. Emotion. Motion. He's going to put it towards emotion. I think that the idea the wife knew when a verdict was coming and what they were arguing about is shocking, and I hope the judge will feel the same way. Also omitted from the motion is any mention of the active involvement of Attorney Shapiro's wife, Kisa, in a social media chat group during trial, as shown in the appendix below. Kisa Shapiro, undoubtedly an agent for defendant, participated in the chat group by advocating defendant's trial positions, just as Jules, whom defendant erroneously claims was an agent for plaintiff, advocated positions favorable to plaintiff. Given defendant's position that the wife's knowledge should be imputed to the husband, Mr. Shapiro is deemed aware of all Kisa Shapiro's posts during the trial and, by not objecting before the verdict, has failed to preserve this entire issue. So now it comes up. SCOTA. We were waiting for this during the trial and it didn't, but now here it is. Okay. None of this internet activity is relevant to the relief sought in the motion without some objective act committed by or in the presence of jury or a juror. The relief requested in the motion cannot be based on post-verdict statements by juror number 1. The motion also relies on statements by juror number 1 after the verdict. On discharging the jury, the court instructed the jurors that they were at liberty to comment publicly about the case, which is correct. The lawyers and their representatives are not permitted to initiate any communication with you about the trial. However, you may speak to the lawyers or anyone else about the trial. It is certainly true that following the verdict, juror number 1 made known his decision to support the verdict for the plaintiff. There is nothing improper in that in our civil justice system. Indeed, all the jurors made their individual decisions public when they were polled after the verdict was read. Moreover, juror number 1's ultimate decision to support a verdict in favor of plaintiff cannot be considered as evidence that he made the decision through misconduct. The evidence properly admitted in this trial provided an ample basis for the jury to decide against the defendant. For example, near the end of the trial, the jury heard evidence from which it could very reasonably conclude that the defendant had deliberately attempted to mislead it and the court about the defendant's accreditation status. If defendant is searching for a reason for juror number 1's decision to support plaintiff in the verdict, it need look no further than its conduct and the conduct of its counsel during trial. Wow. This is smoking hot, guys. This is smoking. Judge is reading every word of this. Indy Cindy, maybe all watching knew their defense was shady. That's what he's saying right here. Part D, the discovery requested in the motion, including a deposition of juror number 1, should be denied. In addition to the defendant's failure to provide sufficient prima facie evidence of misconduct by juror number 1, there is a further compelling reason the court to deny subjecting juror number 1 or his wife to discovery from the defendant. The motion repeatedly invokes protection of the integrity of the judicial process or system to justify the relief it seeks. The cynicism of such statements is remarkable in light of the defense counsel's conduct at the end of the trial and after the verdict. To anyone watching the last day of trial, the disrespect toward the court rulings and later in the verdict was palpable. After the court reiterated it was giving alternative verdict form questions to try to avoid the necessity of retrial, defense counsel said, "You don't know what the law is, and you're going to give the jury both options right now? Is that what you're going to do? I'm sorry, I object to that." Then came...
a low blow because the judge is going to be reading this and he's reminding him how rude the guy was to him.
It's a low blow, but it's also straight out of the court record. Then came the following exchange. The court: "I'm just saying, Mr. Hunter, it seems what you're saying and what I'm hearing and what I'm hearing do not match." Mr. Hunter says, "And what I was also saying, Your Honor, was that you're only hearing seconds-long clips. You're not hearing the whole thing. You're not hearing the entire value, and it doesn't sound like you're prepared to listen to the whole matter." The court says, whoa, time out, because that's a very serious statement you just made. Do you really think I am not making balls and strikes calls? I just eliminated a couple of items from their exhibits, and I'm listening to your statement. So I just want to make sure. Are you saying that I'm closed-minded in this case? Mr. Hunter says, "Judge, I'm suggesting that on this particular issue, you have indicated a predilection regarding the Heart Institute issue that I don't think you're able to get past, and that's my problem with it. And on these particular clips, what you're also seeing, once again, and I hate to sound like a broken record, but you've just listened. This is a town hall meeting that went on for some period of time. I don't know how long it was. They've got a whole clip of it, okay? A whole clip of it, and I haven't seen. And frankly, don't, to this moment, know the entire source of, but you're reacting and visibly reacting to clips from that thing that are seconds long. You're not hearing the whole story, and that's my problem with it, Judge." Defense counsel Shapiro made the same false claims to the media and the public, stating in a media interview just outside of the courthouse on November 1st that the hospital is credentialed by outside agencies that have found that the hospital has always operated under safe environments. Also, as described in the declarations attached here to as Exhibits F and G, defense counsel Shapiro made repeated vulgar remarks while exiting the courtroom in a loud voice and loud enough for everyone present to hear. Exhibit F, Gabrielle Carlson declaration. Exhibit G, Connie Stump declaration. Specifically, Attorney Shapiro said, "Effing ridiculous and effing scumbag family." Attorney Shapiro continued uttering similar expletives and derogatory comments as he walked down the hallway where members of the public and the media gathered throughout the trial. Defense counsel's contempt for the jury was also demonstrated by a social media message from another member of the defense trial team and member of their law firm. Oh, here's Mr. Hughes. Here's the bus stop one. Here it comes. The Attorney Shapiro was included a slur on the jury members as 6 people from the bus stop. "Thank you for your continued help. Next time I'm in blank, owe you one. If your other colleagues have insights, please pass along, specifically on the social media side. As this point, the medical arguments have already been made. And yes, a very important case. We'll never stop fighting for you guys. I'm ashamed of the outcome, especially after so many years, but you never know what 6 people from a bus stop can do." Signed, David W. Hughes, shareholder. Mr. Hughes was one of the attorneys for the defense. Nothing would be more deleterious. What? Deleterious to the integrity of the judicial process than to the subject people who have done their jury service to a deposition or an interview by lawyers capable of such behavior. There can be little doubt that a deposition or interview would be used to further vent defense counsel's frustration and anger on display on the last day of trial. Finally, in regard to the request for emergency relief regarding text messages and other electronic communications for juror number 1 and his spouse, the sole justification offered is the unsubstantiated statement in the motion that defendant has learned that individuals associated with juror number 1 and his wife have begun deleting social media posts. Such statements should be given no weight without further detail and an identification of the source. You had something? No? I can hear you, but I don't think they can hear you very well. Rob, are you on? I'm just looking here. Rob, are you in chat? I have not been paying attention to chat. Can someone tell me if Rob is here? You can hear her, okay. That's good. Let me know if Rob's on. If there's... I'm not going to read this whole document. There's going to be more to go over. This is 150 some odd pages long, and we're where are we? We're at 30 some odd pages in. 34. Haven't seen him in chat yet. Okay, we actually Mrs. R.A. was gifted a microphone. We just need to get the support for it, and then we'll be there. No Rob yet. Okay. Let's see. The defendant's supplement to motion for new trial based on juror's misconduct, motion for juror review, motion to open discovery, and evidence of juror misconduct, and emergency motion to preserve evidence. This is E. Plaintiffs are aware that at 11:54 a.m. on November 27th, defendant filed a supplement to its motion, bringing in extraneous issues in an attempt to slander juror number 1 further. This was literally this morning, just before noon. This is hot ink. This is wet ink right here. So just before noon, they bring in this issue about juror number 1. Plaintiffs do not believe the supplement merits a response, but if the court disagrees, plaintiffs request an extended deadline. The supplemental motion rests on speculation from a matter over 20 years old, affirming denial of a new trial based on legal experience 17 years before the case. Additionally, defendant's supplement asserts that it is reasonable to assume that juror number 1 may have harbored ill feelings towards the DCF, or at a minimum, an allegiance in favor of a party accused of suspected child abuse, like the late Beata Kowalski. Supplement at 2. The prospective juror questionnaire utilized in this case included the following questions. Have you or any of your close relatives or family members had a child sheltered in the protective custody by any government agency such as Florida Department of DCF? And do you, hold any strong opinions concerning the Florida Department of Children and Families or its ability to take children into protective custody? Juror number 1 answered no to both questions. It is not reasonable to assume juror number 1 had feelings of the defense speculates about when juror number 1 answered no to having strong opinions concerning DCF. Furthermore, the defendant asked no questions of this witness about any experience with DCF. It was love at first sight for defense counsel and juror number 1.
Oh my goodness.
Oh my goodness. KBF says the defense simply copy-pasted all the junk Reddit sent them without vetting it. Thanks, Reddit. It seems that they did throw everything in there. I'll give them that. But wow, saying it was love at first sight, that is hilarious. As shown above, the post-trial allegations are irrelevant, and defendant is in no position to complain about its impropriety. See also this case law affirming denial of motion to remove juror for misconduct based on movement's claim of the appearance of impropriety. As shown above, the post-trial allegations are irrelevant and defendant is in no position to complain about impropriety. Wherefore, plaintiffs Jack Kowalski individually and on behalf of his child, Maya Kowalski, a minor, and as a personal representative of the estate of Beata Kowalski, deceased, respectfully request that the court deny all relief requested in this motion. And it's signed by attorney Greg Anderson and team. DSN, thank you for gifting a membership. Thank you so much. That one went to Dolphy Fran. Congratulations. Okay, so we're only a quarter of the way through this. And here's Mr. Shapiro's wife's posts. And here's more of her posts. And more of her posts. And more of her posts. I hereby certify that I electronically filed the foregoing document with the Court of Clerk using Florida's e-filing. That's the end of that. Now we have Exhibit A. Hey, rabid Redditors, take care of Maya free. These are screenshots from Maya. I'm a bit triggered because the battery is only at 75%. I like to keep my battery full. Having said that, mine's at 55. But let's see. Dr. Quack Patrick has a sale. Buy one ketamine infusion, get propofol and Dilaudid for free. Wow. Party at Daddy Shapiro's. These comments are, this is, for those of you who are not on Reddit, this is why you're not on Reddit. It's a lot. Oh
my gosh, it's a thinking jury.
Wow, they've got screenshots of juror questions. Wow. I definitely believe that juror number 1 knows where to get crack. This group, this is where, this is their think tank. Wow. Exhibit B, let's see what we have there. This is, this is the declaration of Gregory Anderson. This is good. This is good. I, Gregory Anderson, Declare under penalty of perjury that I make this declaration based on my personal knowledge of the facts contained herein, and state, I was lead trial counsel in this case and made all command decisions such as strategy, tactics, scope of questioning, choice of jurors, questioning, and every other aspect. My partner, Nick Whitney, assisted on a number of the decisions, but the ultimate decision on all of these was mine. I have read the defendant's motion regarding juror number 1 and the attached affidavit and exhibits by Mr. Shapiro. At no time did I have, nor have I ever had, any conversations directly or indirectly with juror number 1, even up to the moment of this declaration. I have neither met with him, nor have I received any information about or to him, at least until the filing of the defendant's motion. In fact, of all the jurors, I had the least eye contact with juror number 1 during the trial. At no time did anything that he did or did not do have any effect on my overall trial strategy, with the exception of a decision as to whether or not to keep him as opposed to bringing the first alternate juror near the end of the trial. There's Rob. Please tell me the responses you made laugh as much as I did. I knew plaintiffs would respond aggressively, but holy smokes. This is, it's the way they just start from the beginning. Rob, are you going to cover this tonight? Are you back in the saddle, or are you still enjoying the holiday break? Let me know. The turkey hangover. Most of my cat has eaten most of our turkey. I told you that story, didn't I? I cooked the turkey. It was ready like 2 hours after we were done with dinner. And Mrs. R.A. suspects that I did it purposefully just so I can feed the cat the whole turkey. But the cat loves the turkey. Rob, we need you. We're the Rob light has turned on, the robot light. In no time did anything that he did or did not do have any effect on my overall trial strategy, with the exception of whether or not to keep him. Number 5, when the defense filed a motion to disqualify juror number 1, I confirmed that the first alternate was the gentleman seated third from the right with the gray goatee. Hey. Who appeared to be older and generally smiled at everyone upon coming in and leaving the jury box. That included the bailiff, the court, and both sets of counsel. Throughout the trial, as is my typical practice, I closely monitored the questions submitted by juror number 1 and those questions I could discern from the first alternate. My purpose in doing so was to gauge the jurors' reactions to try to discern what questions or reservations remained in the jurors' minds that needed to be satisfied in order for us to prevail. Every experienced trial attorney does this. The questions, from my review and memory of their context, from juror number 1 were incisive and straight to the point, as one would expect from someone with a background in law enforcement. As the court has pointed out, all counsel knew of juror number 1 law enforcement background was from the voir dire process. Questions from the first alternate tended to be favorable to our case. Moreover, his body language when considering our witnesses versus those of defense appeared more positive, at least from my experience. Thus, I concluded the first alternate was more of a sure thing in terms of completing the jury that would ultimately decide in our favor. Juror number 1, on the other hand, was a wild card. His questions of our witness at the start of the case were explorative, and sometimes aggressive, poking holes in our theories and arguments. I had deep concerns over his reactions to our case. However, I was heartened by his questions to the defense, which were equally probing. My decision was that either would probably do well, but I did not have a strong read on juror number 1. When it came clear that I had a choice to make, it took me at least 15 minutes to draw the conclusion that I should probably go with the sure thing, i.e. the first alternate. But, standing in a lectern, with the ultimate decision hanging in the balance, I realized that I had not spoken to the most important person there, which was my client, Jack Kowalski. I learned that Jack and Dr. Scott Richards, our expert psychiatrist, appeared to have a different assessment. And when I consulted with Jack, although I cannot reveal privileged conversations, it became clear that Jack had weighed juror number 1's on the first alternate and the first alternate body language and questions to the witnesses differently than I had. These factors were on my mind as I approached the lectern and ultimately decided to oppose the defense's challenge to juror number 1, awaiting the court's ruling. In no way did I agree with the defendant's allegations against juror number 1. My decision was purely tactical. The record reveals that the basis for removing juror number 1 was thin, to say the least. Only my joining in it would allow it to happen, and the court noted this. Defense counsel noted this as well, at least by virtue of their reaction to my even considering it. And I knew this choice was ours alone. He's talking about the jazz hands. I knew that this choice was ours alone to make. At no time did I draw any conclusions about juror number 1 being anything more than what he appeared to be, a very intelligent former law enforcement officer who asked cogent questions and would give both sides a fair shot. Fortunately, the jury sided with us, but I remain confident that the first alternate juror would have contributed to a similar result if juror number 1 had not been relegated to an alternate status. As to the public observer, known as Jules, I do not recall having a substantive conversation with her. Why can I not say that word? substantive. Conversation with her at any time over the 8-week trial. Then, during the jury deliberations, she brought her lunch down and sat directly across from the 2 rooms we had reserved for our team through the trial. She chose to sit in a position where she could, if she wanted to, pay attention, overhear potentially attorney-client privilege matters. I did not believe that was her intent, though I am always cautious. I spoke to her and told her that I really could not have her sitting anywhere near my clients while we were discussing matters due to privilege. She immediately understood and picked up her food and went down to the other end of the hallway. Mr. Shapiro's photograph reminded me that out of the dozen or so photographs taken of the Kowalskis and our trial team after the verdict, and our photos of the trial team with experts from our case, the photos of the trial team with various persons from the gallery and photos for the Kowalskis and the trial team with various media reporters, that there was one in which Jules is pictured. Although we did not interact with her throughout the trial, she had been present on most days, and I felt a bit bad excluding her from our area in the hallway earlier that day, so we honored her request with a photo. Certainly, she was not part of our trial team in any aspect. During the course of the trial, there were no settlement discussions between the plaintiffs and the defendant. There was no decision to be made and no advantage to be gained by having any insider knowledge during the deliberations about what the jury was doing. The defendant had filed 3 nominal proposals for settlement, and settlement negotiations with J. Hatch had gone nowhere since the beginning of the case in 2018, even as late as the most recent mediation in June of this year. Succinctly, even if there was some plant in the jury who was communicating to us the progress of the jury's deliberation, there was nothing to be gained because there was no discussions. There was nothing to accept or reject. This is all conjecture, of course, because no secret plant or backdoor communications existed. Similarly, there were no joint decisions on major issues, although I did readily accept advice from Jennifer Anderson, Nick Whitney, and upon occasion, Kelly Perry and Samantha Lawrence. Even the input from my team of astute lawyers and paralegals was metered by me. And it is absurd to suggest that I, as lead trial counsel, took suggestions from random people in the audience. I heard at the time and have confirmed in the record that the court discharged this jury and instructed them that they may speak to whomever they wish, with the caveat that none of the lawyers may approach them for comment. Other than that, they were free citizens to talk to whoever they wanted, however they wanted, about whatever they wanted. None of my trial team approached juror number 1 or any of the other jurors. Finally, as the officer of the court, I must point out that my deep concerns over this motion being filed in the first place. From my review of the reaction in the media and public forums, the defense allegations have done drastic harm to the jury system. Oh, this speaks my language. Oh my goodness. The motion doxed juror number 1 and his wife by revealing juror number 1's full name and their shared address in a footnote on the very first page. Now, I realize that by law they have to do this, but I believe they could have filed that under seal. Okay, we would not have been able to see it, but it would have protected it. There is a strident and at times cruel and malicious segment of the Internet's population that is dead set against the Kowalskis and anyone who supports their case. By replacing juror number 1 in the public eye with his name, his wife's name, and their address, the defense places them at substantial risk of harassment and physical harm. The defense took no efforts to keep juror number 1's personally identified information confidential or under seal, despite court's great efforts in this regard. The court should have been aware that the defense never conferred with me or my team at any time prior to the motion being filed. There was no attempt to contact me by phone or text to let us know what was coming or to cooperate to protect juror number 1 and his wife via stipulation or other arrangement that we would not challenge the defense's motion for failure to satisfy Florida law. That's the law that requires them to name the defendant. The defense's actions were in violation of this court's standing order regarding the filing of motions, but much worse, it indicated defense counsel's reckless disregard for potential consequences that could befall juror number 1 and his wife. Pursuant to Florida law, I declare under perjury that I've reviewed the foregoing declaration and the facts are stated and are true. Signed, Greg Anderson. With today's date. Exhibit C. We've got Jack Kowalski. Pursuant to Florida law, declare under penalty of perjury. I make this declaration based on my knowledge of the facts contained herein and state I attended trial almost every day of the trial period, starting September 21st and ending November 9th. I am aware of the motion filed by the defense team on November 23rd, specifically the part about my alleged interaction with Jules during the court's ruling on whether to disqualify juror number 1. The defense's motion alleges that after the court denied the defense's motion and chose to keep juror number 1, I turned to Jules and nodded my head with a smile. This is false. If you watch the video linked to the defendant's motion, I turned to Dr. Scott Richards, who was seated next to Jules in the gallery. In fact, the video provided by defendant shows Jules with her head down at that very moment. At no point did I have any conversation with Jules about wanting or needing to keep juror number 1 on the jury. My purpose in turning around was to make eye contact with Dr. Scott Richards, our expert psychiatrist, who I had found helpful in assessing the behavior of various jurors throughout the trial. Of course, at that point, I was aware of the defense's motion to disqualify juror number 1, and I was also aware of the identity and position of the first alternate juror. Leading up to that discussion in the court, I had several conversations with Dr. Richards in which we traded our assessments and observations of juror number 1 and the alternate in hopes of coming to the right answer. For that reason, I glanced back at Dr. Richards when the court made its ruling. And then it says it made this under penalty of perjury. And that's signed November 2nd, dated November 2nd. Exhibit D. Oh, here we go. Full screen, the bus stop email from David Hughes. Let's see. Here's another one from, this is an email from Mr. Shapiro. Hi, blank. This is so nice of you to reach out with your words of encouragement, especially meaningful coming from another attorney. I do check in on the Reddit threads on occasion. It serves as a great shadow jury. A lot of the commentators pick up on ideas I miss in real time. Thanks for your contributions. I'm super jealous you get to practice in NOLA, my favorite city to get to. As for the jury, there is one outright hostile juror. I honestly believe he is a plant or knows the Kowalskis. I'm holding out hope for a hung jury. Keep in touch. Ethan Shapiro. I'm not sure. Who edited this? Who blocked out that name? Did someone's kid scribble on their screen? Okay. Anyway, Ethan Shapiro writes to somebody who will pretend we can't see their name. Good morning, blank. I want to echo my partner David Hughes' thank you. People like you taking time to fight for justice exemplifies honor and courage. We are analyzing all of this as part of our post-trial motions. And equally talented to scribble. Regarding juror number 1, wife has a close connection to Kowalski's case and documentary and other alarming comments online. The help we've received from folks like you is amazing. Let's keep this quiet on socials for now. I don't want the other side getting wind of all this and help them and then deleting a bunch of stuff, so thanks for saving it all. You're not alone, by the way. We are listening and compiling. Keep it up. Yeah, it's a little bit creepy. More screenshots. Ethan Shapiro. Hey, I want to thank you and everyone else who is sleuthing this carefully and meticulously. I've gone through the Reddit thread on juror number 1 with almost 1,000 comments. We read this one previously. That was included earlier. Exhibit E. What's this? Jury trial proceedings. Excerpt of post-verdict discussions. Oh my goodness. Okay, this is November 9th. This is the day of the verdict. Time 1:46 p.m. to 3:02 p.m. Reported to let's see, appearances. We've got Gregory Anderson, Chris Altenberg, Ethan Shapiro, Patricia Cruels. Excerpt of proceedings, post-verdict discussions, reporter's certificate. The following is a requested excerpt. The court. May I see the attorneys up here for just a moment, please? The following bench conference took place outside the hearing of the jury. The court. Okay, if it's now 1:47, we still have to go over the punitive damage instructions and verdict form. What if I say that we're going to start the punitive damage case at 3 p.m. today? Give this jury a few minutes to stretch their legs? Mr. Anderson. Yeah, we can do it. We can do it. Mr. Shapiro. Can we have a few minutes? The court said. I said we needed to go right away. Mr. Shapiro, we have rebuttal witnesses that we need to call based on the fact that, the reports were let in the terms of the IJ, so we're going to need at least 3 or 4 hours to create a case. The court, well, I would start calling, so... Mr. Hunter, Judge, how long are we going to have on this? I don't want to rush a judgment on this. The court, usually it's, an hour aside? It's not... Mr. Anderson, we're talking about 90 minutes for ours max. It'll probably be less than that, less than an hour. Mr. Hunter says, Judge, it's going to take us at least 2 hours to put our case on, if not longer. Court says, so we can start at 2:15 then? Mr. Hunter, we'd like Monday to be able to come back here. The court, we're going tonight. I told you we're going. I gave everyone fair warning we're going. So the only question is, do we start at 2:15 or 3 o'clock? Mr. Anderson, either way. Mr. Hunter, I would say 3 o'clock, Judge, but I must respectfully protest. We're on Thursday before a holiday weekend. You're going to be keeping them until 6, 7, 7:30, 8 o'clock at night. I just don't think this is appropriate. If we need to come back happens all the time in tobacco and other cases, and I don't want justice and fairness to be sacrificed on the altar of expedition here. The court, well, Mr. Anderson, we want to go. The court, it's not a question of surprise because I've been telling everyone to be ready to go, so why don't we say 2:30 then? I'm going to let the jury go stretch their legs. We'll deal with the jury instructions and verdict form, and then everyone can make their call. We're going to take a 5-minute break, and then Mr. Hunter says, I'm sorry, Your Honor, can I inquire who plaintiff intends to call? Mr. Anderson says, we've got Mr. Heese and Deborah Salisbury, and perhaps by Zoom, Dr. Corcoran again, but probably not. He's actually got a medical procedure. The court says, everyone just step back, please. End of bench conference. The court says, okay, members of the jury, your service is not yet complete based on the questions that you answered. We're going to move into phase 2 of this case. My goal is to try to start phase 2 about 2:30 this afternoon. I'm going to give you all a few minutes to go stretch your legs. You cannot discuss this case further amongst yourselves. You cannot get any further information. You cannot do any research. Do not review any media accounts of this case. Do not let anyone approach you about the case. Do we all understand that? All who answered, yes. Okay, have them back by 2:30. I'm trying to see where this goes. So they keep talking. This bench conference continues and continues and continues. Still going. The court. Whoa, whoa, whoa. Time out, time out. I like that. Right here, we'll just highlight that. That was when Mr. Hunter was making faces and stuff. Let's see. Keep going, keep going. They're talking about the clips. Transfer things back and forth. That's the end of the recount. This is just the registered reporter saying that this is a true and correct copy of what happened in court. Okay, here we go. This is the one we want. Gabrielle Carlson. I, Gabrielle Carlson, pursuant to Florida statute, declare under penalty of perjury that I make this declaration based on my personal knowledge of the facts contained herein and state I am a law clerk with Anderson Glenn, who is the plaintiff's attorney, and assisted plaintiff's counsel throughout the trial. On November 9th, shortly after the verdict was read, I exited the courtroom before the court took a recess ahead of the punitive damages trial. My purpose in exiting was to begin printing those documents necessary for the punitive damages trial, and our printer was located on a small table just outside the courtroom doors. I was sitting on a bench directly outside courtroom D's doorway with our legal team's assistant, Connie Stumpf, facing the courtroom doors. Less than 10 minutes after I relocated to the bench just outside the courtroom, I heard a loud noise, looked up, and saw the double doors of the courtroom swing open. Mr. Shapiro glanced at me while moving quickly out of the courtroom and to his left down the hallway. As he exited the courtroom, he loudly exclaimed, "Oh my goodness. This right here." This is what he exclaimed. Something, it's blurry on mine. It's redonkulous, something like that. It says it's, wow. He says, effing ridiculous and effing scumbag family, and continued muttering other similar explicit phrases as he walked down the hallway with Miss Lessing, the defense team's paralegal, behind him. He repeated these expletives and other similar phrases as he turned the corner to the room utilized by the defense team. Mr. Shapiro's comments were made in the hallway where members of the public and the media gathered throughout the trial. And they're saying it's true. And then we have a virtually identical statement by Connie Stumpf, who was out there as well. After the verdict was read, I exited the courtroom, took recess ahead of the punitive damages trial. My purpose was exiting to print the documents necessary for the punitive damages, and a printer was located on the table outside the courtroom doors. I was sitting on the bench next to the law clerk with our officer, with our office. Gabrielle Carlson directly outside the courtroom D's doorway, facing the courtroom doors. I can corroborate everything within Ms. Carlson's declaration being filed contemporaneously, especially the statements made by Mr. Shapiro. Mr. Shapiro's comments were made in the hallway where members of the public and the media gathered throughout the trial. Signed, Connie Stumpf. So remember when Jules called in and said that that Mr. Shapiro might have made some rude statements, said some not nice things. Is that a pattern of behavior? So Exhibit H, let's see. It just starts. I don't know what it is. It's weird that there's no, let's see. Is there anything about either the particular case or death by suicide that you hold any sort of strong? Oh, this is in voir dire. Yeah, this is voir dire specifically regarding juror number 1. And that ends it. That's we've scrolled through a lot, but that's the full response filed by the plaintiff's family. Wow. Let's see. Will you transfer us to Megan Fox's stream? She'll be on with Greg Anderson later on. Let me see if she's up. What are your thoughts on this? Let's see. Hang on. Rob says check your phone. Hang on. 1 second. We might have competing streams to split our attention with. Just 1 second here. That's awesome, Rob. That's awesome. All in good time. This is crazy reading this. Let's see. Thoughts, questions, comments, criticism? They still don't get it, says Amy. Now my cruise is all ruined. How am I supposed to enjoy my cruise after we just lost a $261 million case? Mara C says, this was much better than I thought and hoped it would be. I called them out on all of this. They did not shy away from anything. Not at all. It's 15 minutes before Megan goes live. I'll check. I don't know if, Rob, are you going live tonight as well? Who said something about lawn lumber? Said something about Mrs. R.A. Whose voice are we hearing? The voice of reason behind us? Please tell me I'm hearing Mrs. R.A. in the background because it's so needed for this response. Also, check your phone. Yes, Mrs. R.A. is right here. She can almost reach.
I just want to say, Jules, man, I am so sorry they put you through this. I mean, obviously, I'm sorry for the Kowalski family and everything that they have been put through. But to see this on they're dealing with people that we actually interact with, and you get to see how they're treating people. And I am sorry that they just ran the bus right over you. That was... Scott's got a very clean channel here, and I'm just not going to go where I want to go on this. But wow, Jules, not cool what they did to you.
I think what she says is she's thinking some Shapiro words. That's what she's thinking. Not that bad. But I did see the amended motion defense filed. I think I like the response the plaintiff gave on that one. Honestly, it seems like they're trying to dig up every scrap of dirt they could find and make it have meaning, and I don't think that one did. And what they tried to create and thread together out of something that I don't think existed was artistic at best, but entirely not probative. Okay. Let's see. I would have let out a few choice comments if I lost a $200 million case. I don't want to blow it out of proportion, especially when some of the other stuff is worse. Not cools to Jules. We are so sorry. And Jules, is Jules in chat here tonight? I'm not sure if she's here. I'll send her a message. I need to get something for her. I did. We have created a hoodie for Jules. I need to get it to her. I need her shipping address. You can see her hoodie. You can actually buy her hoodie, but it says Jules on it. But I can only make it possible by shipping it to her. So I don't think there's any threat of disbarred. Lawyers say things all the time, and they're human as well. I don't think this, at least in my knowledge, I don't think it comes to anything about being disbarred. If there was a willful and purposeful action that violated the law, that they did something intentionally illegal, that's where you start getting into ramifications that way. But just by him being upset about losing, I don't think that would. Jules, I just text me your shipping address and what size of hoodie you want again, because we've got the hoodie built. I need to get it to you. But that was it. It's Notorious Jules, right? Notorious. That's wonderful. All right. When will we hear about sanctions? Here's what we know. The docket shows that on the 15th of this month, there is a hearing in courtroom 6C at 8:30 in the morning. And it just says motions. So I envision that all these motions will take place at that time. Some of them may be addressed quicker, so there's a possibility that the court finds time, if it only needs like an hour or so to get rid of a certain small motion. They might get rid of that if they have a little gap somewhere, so that could happen before then. But at least by the 15th, I think we'll have some sort of feedback on this. I've not seen, Rob, are you going live tonight? He might be off reading or researching or on his own live stream. I'm not sure. Mrs. Ari has a thought again.
This has been a really fascinating case from beginning to end, but I think this part of it, what I find most interesting is what they're doing to the jury, like the attack that has gone to this one individual. And I just feel like, what are you doing to the integrity of being on a jury? Can you imagine the rest of the world getting a jury notice and thinking, in Florida, please no, I need to move now. You've created this space where being called to the jury becomes terrifying, and voting against the big and powerful individual becomes personal and becomes something that they're going to come after you individually if you don't agree with them. This is massive. The implications of this are so big. They're so far-reaching. I am like jaw-droppingly disturbed at what is happening here. I think there needs to be a lot more respect to what goes on in a jury. Leave them alone. Let them do their job.
I think the phrase is it creates a chilling effect on people being willing to serve on a jury if they get treated this way. Where there is, as far as we can see, and as far as the plaintiff's counsel can see, there is no evidence that a juror did anything wrong. And then this is what their history in court from 17 years ago is dragged out in public. They're outed in public. Their name, their address is put on the front page of a public filing. I think it gives jurors reason to pause and say, I'm not sure if I want to serve because this could happen to me. And I think if anything, that has damaged the integrity of the whole process. I love the idea for the bus stops here merch. The jury bus stops here. Plot twist, I have jury duty on December 7th, says Jenny B. Congratulations, Jenny. Did you get selected or is it the voir dire you get to sit for? Both of them are exciting. And when you can talk about it, we'd love to hear. Only if you choose, though, because that's your right. Let's see. Judge Carroll will see right through the defense notions. Here's what I think. Judge Carroll has proven over and over again that he is able to look at both sides and do so fairly, even though both sides riled him up. There were times he was equally furious with each side. But he's able to stop and reset and rule fairly, which I think is an incredible asset to any court, that a judge is able to sit back and look at it just based on the law and separate his feelings from what actually he needs to do. I thought government wants us to take the bus more. I'm so confused. Rescue dogs. Laura Ann, thank you for the super sticker. Critical hit. Finish him. I got chosen for jury duty, but the trial is getting pushed back. Cross your fingers for a January date. Parrott Court. Are you in Sarah Boone's county? Just asking. Just asking for a friend. When I had jury duty, I legit rode the city bus. There's nothing wrong with this. The bus is awesome, and they use it as like a slang. Yeah, they still don't understand. All right, we are going to wrap things up tonight. Megan Fox has a live stream where Greg Anderson, the author of the document that we just read, is going to be. Here, let me go to this screen so we can talk amongst ourselves. There we go. Okay, Greg Anderson is going to be on with her. He is going to be on with her reading the document that they filed today and probably giving some little insight and juicy tidbits. It starts in just a few minutes. I think it's, what does it say? Let me check the time. It starts at 7:15, so we have 6 minutes for this to start. So if you'd like to get some behind the scenes scoop, Megan has done a great job. She's fostered a great relationship with the plaintiff's counsel, specifically Mr. Anderson. They're both authors. They have some similarities there that they connected on, and she's done a great job following this, and not just this trial, but this is something that this larger issue has been something she's been following for a long time. Also, one of the many minds out there on YouTube, as we said, there are many different minds on YouTube. They handle it differently. She handles things differently than I do on my channel. That's all right. That's all right. We're not the same person. We're not married to each other. And even if we were, my wife says she's married to juror number 1. so just because I sent you over to her channel, don't think that that I am her and she is me. I appreciate the variety and the different perspectives that all these amazing, smart people have about these issues that we hold in common, that we're interested in. So I'm super excited to hear what she has to say, especially with Greg Anderson on tonight, again, as she's had him on previously before with a great interview. So we are going to redirect over to her channel. I would ask that when you drop in there, even if you don't plan on staying, if it's too late for you or something like that, hit the like button. I will say that it takes a lot. It takes a lot to put together a YouTube channel and run it on a daily basis. The effort, the mental acrobatics that are needed are insane. Just on a technological side, it's ridiculously complex, and oftentimes doesn't work the way you want to. She has worked her way through that and done a great job doing that. So just hit the like button as a thank you for her efforts in that area, even if you're not staying. And if you are staying, hit the like button and say something nice in chat. That would be wonderful. So I think that is it. Is there anything else we need to go over other than that it's late at night and I need to go to sleep eventually? Oh man, I think that's it. Okay, I will portal you guys over here when the music stops. If you wait about 15 seconds, once everything ends, there will be a pop-up on your screen. You don't have to do anything, and if you want to jump over there, that's great. If you want to go watch somewhere else, that would be wonderful as well. We have some great people out there. I think Melanie Little is live right now, talking about the Maya case as well. Melanie's done a great job. She's got some great insights as well. If Rob goes live tonight, of course, I'll be over there. Kurt did some great stuff as well. We portaled to him earlier in the day as he was doing a reading. Great things, basically all over YouTube. There's a lot of options, and I encourage you to look around and find those that speak to you. So thank you very much. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe till we go live again, which will be tomorrow morning about 9 o'clock. Our pro se guy didn't show up in court today, so we're not sure what was going to happen. We thought there was going to be a court there today, but we'll see. We'll see. All right, thank you, everybody, to my amazing mods who keep the chat functioning, and welcome, everybody. Thank you. I could not do this without you. It would not be the same without all of you here. Thanks for making this the most enjoyable place to watch true crime. It's because of all of you. You guys have a good evening. We're going to wrap it up here, and I'll see you over on Megan Fox's channel with attorney Greg Anderson tonight in 2 minutes. 2 minutes. Here we go. So we have to, let me see. How much time do I have left on my song? I've got 30 seconds. There it goes. Everyone buckle up. We're going to portal. We'll see you later.